Good morning and good afternoon to all our viewers who have joined us for the launch of CIArb's first virtual event taking officially place in Pakistan. We'd like to thank all of you who have shown their interest in joining us virtually from multiple jurisdictions, namely the UK, Singapore, Australia, and the US, and Asia and Pacific. The event is primarily focusing on the official launch of Chartered Institute of Arbitrators, which is generally known as CIArb, and their first footsteps in Pakistan. We have an esteemed panel of speakers lined up today, and which includes two speakers who will be joining in a hybrid mode from London. From one of them is from the CIArb's headquarters, and the other one is also based in London. And two speakers, namely, will be joining us from Pakistan. At this point, we'd like to also thank Karachi Bar Association for providing us the opportunity to give us the time and the audience in promoting and helping us with the launch of CIArb's Pakistan branch. The esteemed speakers include, namely, the first speaker we'll have online is Mr. Tom Catman. Tom Catman is the Deputy Director General for CIArb headquarters, and his main task is to promote the compliances, and it cannot go without saying that it was because of him that we were in a position to jot down things for the CIArb Pakistan chapter. And with his support, we are in a position to actually launch this official program. The next speaker we will have in line is Mr. Nasir Khan. He's also a qualified legal professional, and his legal expertise spans over 2 decades, and he's currently associated as a director for Karachi Brand. The third speaker we'll have in line will be Barrister Nia Javed, who joined us in Karachi physically and is traveled all the way from Lahore. And he also has a legal experience of over 2 decades, with the primary focus on construction law and adjudication and arbitration in particular. In the end, we eventually also have the speakers from Karachi Bar Association, namely and most importantly, Mr. Naeem Qureshi, the current president of Karachi Bar Association, followed up with the General Secretary, Mr. Amir Maraj, who will be giving their feedback in the end. So the primary purpose of this online event is to officially announce the launch of CIArb Pakistan branch. Just to give everyone an overview with the audience, which is also physically present over here at the Bar Association. The event, Chartered Institute of Pakistan of Arbitrators, has been working with the dispute resolution fraternity for more than 100 years. The Royal Charter was granted more than 100 years ago by the Queen, and at this point in time, it spans 41 branches in multiple jurisdictions and has over 16,000 active members within the fraternity. The purpose of this launch was to promote what CIArb is doing and to actually raise the standards of dispute resolution, and in particular the arbitration side, which has evolved over the last couple of years. With this, I'd like to welcome Mr. Tom Catman, who is the Deputy Director General for CIArb, and he's joined us live from the CIArb's headquarters. And we want him to specifically focus on the fact what CIArb is actually doing at this point in time, and how will this benefit the legal fraternity in Pakistan. Over to Tom.
Thank you very much, and good morning and good afternoon, everyone, from a wet and windy corner of the English countryside. It is a great pleasure to be speaking to you today in anticipation of the launch of CIArb branch in Pakistan. On behalf of all of us at CIArb, you are an utmost welcome addition to our organisation's ever-growing roster of experts, academics and practitioners that all help further the development of alternative dispute resolution around the world. Law used to be seen as a purely domestic discipline. Its development, adaptation, and evolution all centered around looking inwards to domestic needs and local trends. The idea of the law as a tool primarily concerned with domestic affairs is simply no longer accurate across a multitude of legal disciplines. Me speaking to you today from half the world away is in and of itself proof of the ever-continuing globalization of the legal field. However, it is not only enough to educate yourself on the internationalization of law. As our world becomes more connected, more entangled, the complexity of pursuing legal recourse grows proportionally with it. In 2019, almost 1.7 million cases were pending resolution in the Pakistani courts, as the conventional court system could no longer keep up with the incoming caseload. Safe to say, this experience surely must have been excruciatingly painful for judges, advocates, and litigants alike. Pakistan, however, is not alone in having experienced this sort of legal pile-up in recent memory. Following the onset of the current COVID-19 pandemic, the British justice system too became overwhelmed by the number of cases. When faced with this new reality, legal services providers in the UK quickly started to adopt emerging technological solutions and new practices in order to combat the enormous caseload. In a similar spirit of solution orientation, Pakistan looked to its legislative, who quickly passed a series of ADR-friendly legislation to address the situation, beginning all the way back in 2017. These included the Islamabad ADR Act of 2017, the Punjab ADR Act of 2019, and the Code of Civil Procedure Sindh Amendment Bill of 2018. As an organisation that seeks to promote the facilitation of alternative dispute resolution and improve access to justice for all parties, we applaud the steps taken by your country's government towards easing the strain on the national courts and open up Pakistan for faster, safer, and more secure routes to procedural justice through ADR. The real reason for celebration, however, is you, the legal professionals who will seize this opportunity and come to make Pakistani ADR famous the world over. We want to support you in this endeavour, which is why, alongside with us opening a local branch here in Pakistan, we would like to let you know that we extend our full support to you in the development of the practice of ADR in Pakistan. In terms of our commitment to the furtherance of ADR, we provide thought leadership, education, training and professional services, academic and professional resources, as well as an approachable route to membership in a truly global community of peers and professionals of over 16,500 members worldwide and a further 8,000 student members. Through our international communications program, we seek to promote greater understanding and use of alternative dispute resolution methods by working along professional organizations such as yours throughout the world and through the engagement of their local members. We also offer a wide range of professional courses, trainings, and vocational programs, all widely recognized and globally respected as the gold standard for bespoke ADR education. It is through participation in these events that membership in CIArb can be obtained. As an international leader in dispute resolution, our main focus as an organisation is to advance and promote the development of ADR. To this end, our policy and research team and legal services function work closely with major law firms, decision makers, and prominent leaders in business and society towards being able to offer its members, as well as the general public, a wealth of information and guidance in support of the work of ADR practitioners. Last, but certainly not least, we provide our members with unparalleled access to a global community of like-minded peers that can go far in furthering your own career and professional development. We can offer the following concrete support to you. The introduction programs and assessments in ADR, domestic arbitration, international arbitration, mediation, and construction can lead to associate membership and are delivered face-to-face, virtually, or in the form of an online e-module. Our year-long pathways in the same disciplines have been designed for those with no experience or background in these disciplines, and successful completion can lead to membership if Module 1 is passed, and fellowship if Modules 2 and 3 and a peer interview are passed. These again are delivered both face-to-face and virtually. For those of you with relevant knowledge and experience, we offer accelerated assessment-only programs in domestic arbitration, international arbitration, and construction adjudication that can enable individuals to be assessed for membership and fellowship. Again, these can be delivered face-to-face and virtually, and we're looking forward to assisting the branch in delivering some of these trainings face-to-face over the coming years. We also offer face-to-face and virtual diploma programs in international commercial arbitration and international maritime arbitration, leading to membership and fellowship. We can also support jurisdictions by providing bespoke judicial training to upskill the judiciary in their knowledge of ADR, and also support universities by supplying ADR modules to be inserted into their LLM programs. In addition to our programs and courses, we believe in professionally developing our members, and we produce ongoing skills courses for renewing old knowledge and attaining new skills for old and new members alike. By way of example, we have just launched an online module on award writing. CIArb membership enables individuals to access thought leadership, guidelines, ethics, and other resources, events, and membership benefits, social as well as professional, throughout their career. The COVID-19 pandemic has put focus on some of the key benefits of ADR. When domestic courts became overloaded with incoming cases, ADR practitioners stood at the ready, prepared to assist in resolving conflict expeditiously, securely, and at a suitable expense for the parties. The pandemic, however, has also presented several obstacles for practitioners globally. A plethora of abstract disputes arising from force majeure, impossibility, or frustration has, together with compliance and supply chain matters, come to ask a lot of mediators, arbitrators, and other neutrals. Access to justice is another area where we are currently seeing plenty of challenges to parties, in addition to practitioners. Being able to rely less on traditional means of dispute resolution has supercharged the development of new ways to connect with would-be litigants, and parties are entering into procedure in a whole new way compared to what we saw only a year ago, with practices like ODR, online dispute resolution, taking a much more prominent role. The pandemic has, however, not only brought with it challenges. It may well be the case that it turns out to have been an opportunity for online mediation to be adopted more commonly in disputes that ultimately would have been referred to international arbitration. Seeing how mediation up until this point tended to be more common in a litigation context than arbitration, this could be the start of a major shift in how dispute resolution is approached from the outset. However, in regard to the choice of dispute resolution mechanisms in general, it remains likely that, in the wake of uncertainty created by court closures and delays, contractual parties may seek some comfort in the arbitration process as an alternative to the bureaucracy of the state, even after the pandemic. In the wake of the pandemic, parties might also reflect on their governing law and choice of jurisdictions for agreements to a greater extent than before. There is a risk that commercial litigants move away from those jurisdictions that have been badly affected by the virus, and instead decide to resolve their disputes in jurisdictions that were either less affected by the pandemic or were better able to keep their judicial functions open and operational during the crisis. In short, while the current reality has presented several challenges to the ADR industry, the future most definitely looks bright. Practitioners and parties have had to adapt quickly to our new shared reality. But in doing so, the inherent value of resolving disputes through non-litigation means has been on display more than ever. In an article in 2019, Syed Abbas Hussain of the Adr Foundation expressed how alternative dispute resolution promised to have a trickle-down effect on other parts of society. The swift resolution of commercial disputes, where ADR has been gaining traction for years, should improve the confidence of domestic and foreign investors in the value of Pakistan as a destination for foreign investment. This proposed turn of events has precedence. After Turkey adopted ADR positive legislation in 2018, this strongly promoted mediatory avenues to resolving disputes, with a record number of cases being submitted for mediation with a settlement rate of over 75%. The Turkish model owes much of its success to the training standards imposed along with legislation. Pakistan has already begun the work with passing the right legislation that will give the practitioners the tools necessary to utilize ADR. The next step is to set up a system under which proper education is afforded to legal professionals. CIArb cannot sway the opinion of Pakistani decision makers. What we can do, however, is bring the absolute cutting-edge knowledge and thought leadership from around the globe to Pakistan. Opening our local branch here is the start of a joint venture between CIArb and the legal industry in Pakistan, and we hope that you will indeed join us and together help further and develop ADR both locally and globally. Thank you very much.
Thank you, Tom. I think that was a great insight on what CIArb is currently doing and how they also have a key interest in the legal market of Pakistan. I think we already have a couple of vendors registered with CIArb, but with this also launch, I think the intent to grow the platform on a much broader scale and join hands with the fraternity collectively. So the next speaker we have tonight is Mr. Nasir Khan. Nasir Khan is again a legal practitioner, but also a fellow of Karachi Bar Association. Currently, he's associated as a director with Karachi Brown. Nasir, I'd like you to give an insight on how ADR is not a threat to litigation, rather it's supporting the litigation and the legal system, and how vendors in Pakistan, or the prospective vendors in Pakistan, will benefit from CIArb's model.
Thank you, Mustafa. Assalamu alaikum, everyone. Good morning, good afternoon, good evening, depends on your jurisdiction where you are. Thank you very much for having me on the panel. Thank you, Karachi Bar Association. Thank you for all the attendees who are listening. And I can already see there is lots of questions coming and discussion happening in the chat box, so please keep it coming. Just to give you a bit of my background, Nasir Khan, a strange career I've had, being an engineer, a chartered quantity surveyor, and legally qualified. So I try and dip in and out of various different things. I want to talk to you all about global perspective of ADR in comparison with what's happening outside and how those lessons learned can be implemented in Pakistan and we can benefit from it. A little bit about what I do, where I work. So I work for Karachi Brown, which is a global consultancy where we strive to add value to projects through a proactive approach. It's very much through the whole project life cycle. So we have a global reach, offices all around the globe, and deliver on various projects, specifically within infrastructure, both public and private, on commercial developments. So that's just a bit of an overview of where I work. I head up the contract solutions team. So my portfolio very much spans in procurement advisory and dispute resolution, so offering expert witness services for the legal fraternity. In terms of the key thing that I want to talk about is continue with the subject that Tom mentioned. It's about the rule of law. The rule of law is the basis of order and just conduct in our society. Its absence leads to distrust in institutions and the justice system, the free association that we have amongst each other. The preservation of the rule of law rests on equality of access to the law. Tom mentioned the backlog of cases. Some civil cases may take up to 10 years to resolve. So the inability to access justice when it is beyond the reach of a common person means the rule of law suffers everywhere. And this is a fundamental point from a CIArb manifesto perspective and the judiciary's perspective, that access to justice is a fundamental right, and an efficient and cost-effective justice system is of vital importance to the financial, commercial, and industrial life of Pakistan and of any country globally. Now, we know that globally, the strength of the court system has evolved over centuries as the standard method of resolving dispute. Pakistan, or in fact any other jurisdiction like England and Wales, we have seen the court system, it has always been a superior way of settling civil disputes. I'm going to focus on civil disputes mainly because on the subject of ADR. Now, principally, it is due to its independence, the rule of procedure, evidence, which have been refined over the years, which provide fairness and transparency to judicial decision. However, we all know access to justice is not as straightforward as it might seem. When an overburdened and unaffordable justice system prevails, we have to look at other means. And this is where other means, the alternative form of dispute resolution, comes in. Now, litigation has been the norm, and anything that is outside of litigation, as you can see on this slide, anything on the left side of a litigation trial, that's alternative, whether it's arbitration, whether it's early neutral evaluation, whether it's mediation or facilitation. And this is where the disputes resolved through ADR prevail and provide that affordability. ADR has a vital role to play in reducing the costs of civil disputes by fomenting the early settlement of cases. And we know ADR globally is underused. Its potential benefits are not as widely known as they should be. Now, the recommendation from Lord Justice Jackson back in 2009 was very much that a serious campaign needs to start to ensure that all litigation lawyers and judges are properly informed of how ADR works and the benefits that it can bring. The public and small businesses, I mean the users of ADR, they need to be aware of the benefits, because that terminology, see you in court, we need to get over it. And the terminology now needs to be see you in ADR. So those are the crux of the matter that we need to think about and work on. I just want to work on some key aspects of the success of ADR. And some questions have already come in, and I will discuss those disadvantages as well. Now, it is the success of ADR that persuades parties and their lawyers to use it. And the information I'm giving is from global research that has been conducted on ADR matters. Now, research and statistics generally show good rates of success and good levels of satisfaction. The doubts and the costs of litigation are ever increasing, and benefits of ADR, the potential for cost saving, speed of settlement, the control of process, confidentiality, flexibility, I can go on. They've all been evidenced. Now, we cannot disregard the potential issues of ADR as well, because they are also well documented, generally attributed to inappropriate mechanism, inappropriate time. Failed ADR causes additionally expense, and the dispute ends up in litigation anyway. I've been speaking to many people in Pakistan, and one of the key things we've discussed is going to ADR is just an additional step on litigation. And I found it really, interesting, because the potential strategic use is also very much evidenced. So on that, I'll move on to some specific areas where the growth of ADR has taken place, and I'll give you an overview of the last, say, 30, 40, 50 years. Now, there is a perception that ADR options are relatively recent developments. However, it has always been possible to settle a case rather than to go to a court. Parties always do settlement. Parties always negotiate. That not every case ends up in court. So that is ADR in a way. So that has been happening for centuries. Tribunals to adjudicate disputes with administrative agencies have grown throughout the last century, whether they are insurance disputes, whether they are ombudsman services. Now, area of employment law has seen a substantial growth globally, where the ADR provisions seek to resolve a dispute and move forward rather than to take an adversarial approach. And this is where some of the key difference come in between ADR and litigation. Litigation is very much backward looking on the facts, whereas ADR is very much forward looking, so that collaboration and that relationship continues. And this is an important aspect. It's about building those bridges and continuing with the relationship rather than the relationship ends up in court. So there has also been steady growth in recognition and support of ADR options within the statutory, legislative, and within the litigation system. I think Tom mentioned the ADR Act 2017, then the Punjab ADR Act 2019. I think there is a bill of civil procedure rules. So all of these things, specifically in Pakistan, are the legislative provisions available to us as the general public and the users and the givers of ADR practice to make sure it happens. And there is a plethora of local cases that support all of this. So I want to talk a little bit about global ADR findings, because my specialization is within the construction sector, and I follow religiously a report that is published by Arcadis, another global consultancy service. And the examples on this very much are in terms of just looking at what are the potential causes of disputes. Now, the key thing is disputes, specifically in construction industry or in any industry you look at, whether they are commercial in nature, I'm talking about civil disputes, they're generally misunderstandings, because that's the pure definition of a dispute. A misunderstandings that the parties aren't able to handle or resolve themselves turns into a dispute. So as for the most used methods globally, this is something you will find hopefully very interesting. Arbitration continues to be the most used adjudicative method in the construction industry, not litigation, it's arbitration, a form of ADR. Only in continental Europe does litigation make the top 3 list. So what I'm showing you here is the global element. There is a regional continental effect available as well. In all regions, the top 1 dispute resolution method is party-to-party negotiation. Now, when I say party-to-party negotiation, parties don't just work themselves and do it. They still need help with ADR practitioners, whether they are lawyers, they're cost consultants, they're experts, to give them an opinion of their case, to give them an option to settle. The effect of COVID-19 will be, inevitably significant for the industry, infrastructure sector, etc. We're still debating on various jurisdictions whether COVID is a change of law, force majeure, or frustration. However, the encouraging point is that parties are looking for collaborative solutions. So we need to look at that. And when I say collaborative solutions, parties are really working together and there is a willingness to compromise. Not everybody wants to fight in court, regardless of how strong their position they feel may be. So this is where the importance comes in, that the aim is to create a win-win situation between the party and focuses on consensus building and the future oriented look. Now, based on these global findings and what Tom mentioned earlier and throughout what the speakers will say, my conclusion very much would be what's next for Pakistan in terms of closing the implementation gap of ADR. So as per the 8th Judicial Conference recommendations on how institutional professional development needs to happen for both the givers and users of ADR. So ADR, as we know, is fast gaining traction in Pakistan. It has been gaining traction. I've seen the Law and Justice Commission report where only in the last 2 years, over 450,000 cases have been settled, mainly family, but they've been resolved through the court accessed mediation service, court annexed mediation services. So it's important to look at how the success of that has been, and only 1/4 of the cases were unsuccessful. So we need to look at that 3/4 is still managed to be successful. So that becomes an important aspect. As we emerge from the pandemic, we cannot afford to waste the opportunity to do things smarter, faster, and ultimately more productive. For this ambition to succeed, for CIArb Pakistan to succeed, for ADR to succeed in Pakistan, we need to make the most of the global expertise available. The success or failure of ADR is often determined in its early stages. Whilst success may seem like slow at the start, we may seem, nervous, confused. What are we doing? How is it going to pan out? I think what we need to understand is that it will be repaid many times over later on. So we must persevere and get it right. And I will end on an ayah from Surah An-Nisa, ayah number 35, which mandates us to conciliate and appoint an arbitrator. And I'll just read the translation to end my talk. If you fear a breach between them, the ayah mentions about a couple, appoint two arbitrators, one from his family and the other from hers. If they both wish for peace, Allah will cause their reconciliation. Indeed, Allah is ever all-knower, well acquainted with all things. On that, I wish you all well, and thank you very much for having me on this journey.
Thank you, Nasir Khan. I think that was much needed input of what Pakistan actually needs and why ADR is the upcoming thing that should attract the fraternity. But I think most of the audience generally who joined us remotely and also those who joined us physically, they're no concerned about, because obviously as lawyers, everyone fancies litigation. So in terms of litigation and in terms of this field coming to Pakistan, in terms of dispute resolution, let alone the upcoming new cliche that is known as online dispute resolution. I think I want Barrister Mia Shiraz to give us an industry outlook and how the CIArb Pakistan branch will actually engage more lawyers, get more work from them, and get this reputation of arbitration to a certain level where the engagement from the fraternity is coming from all ends. So the next speaker we have online is Barrister Mia Shiraz. He'll give us an industry insight of how the launch of this branch will be more beneficial to the lawyers specifically, let alone the other ADR practitioners. Thank you, Mr. Bhatt.
My fellow respected members of the bar, and everybody who has joined us online, Assalamu alaikum. It's truly I'm privileged and honored to be here at one of the largest bars of the Bar Association of Asia. I would like to share how how our journey started of bringing Chartered Institute to Pakistan back in 2018, when myself and Nasir we got admitted as the fellows of the Chartered Institute, and then we got to know that there are around 55 other members from Pakistan, and I have been part of the Pakistani legal system. We never had the option of having the rightful information about the Chartered Institute, why that training of becoming an arbitrator was necessary, and what are the benefits that we could get. But once we got that information, it became our dream to convince the Chartered Institute about opening up a branch in Pakistan, which was not an easy task. We had to convince the board of trustees and the senior management of the Chartered Institute that Pakistan is actually a place worth establishing a branch. And we do have those new beginnings and opportunities coming in. I would like to share that business case which we presented for the board of trustees, as it will help, especially the young lawyers, to choose a better career pathway for their future. So our business case was consisted of two folds. One was the international arbitration business, which was coming in Pakistan. That was the China-Pakistan Economic Corridor. We, at that point of time in 2018, part of the CPEC projects were being executed, and all these 70 billion US dollar worth of projects, they had to undergo international arbitration, because in all these international contracts, there is no such provision of having getting into the national courts. And at that time, the Aramco oil city worth around 20 billion US dollars. The rumors were like going on and off that they are about to come in Pakistan, start developing that oil city. So that was part one of the business case. The international arbitration, we do lack the expertise. We don't have the adequate people who can actually cater all these arbitration things, for like the bidding contracts and all that, so on with the CPAC. So who is going to conduct all these arbitrations and all this business? Probably the foreigners are going to come in. We don't have the right expertise. So that national arbitration part is very much there. And then with Allah's blessing, probably during those days before we presented our business case to the Chartered Institute, the Honorable Supreme Court in their 8th judicial conference, they chalked down a few recommendations which were presented before the government. And the recommendations were that at that time we had around 1.5 to 1.7 billion pending cases before various courts right across Pakistan. And it was recommended that we need to introduce some alternate form of ADRs, some mandatory provisions, so that the load can be shifted from the judiciary to other sectors of ADR. And in that way, we can not only address the backlog of like around 1.5 million. It's not 1.5 million rupees that we can just sit it down. There are like 1.5 million cases. Probably in Lahore, like we have got around between 200 to 400 cases fixed before a civil judge every day, which is technically not even possible to browse around all the files like in a day. So we need to have alternative sources coming in, and in case like after that recommendation, we used to think in case if the government, like the legislators, they decided to actually introduce the mandatory form of ADR, we don't have the tool available of like in terms of like lawyers are the first point of contact who understand the legal terminologies. They actually go and present the cases before the courts, and they are the first ones who can be trained as arbitrators. And then I still think this is going to be a challenge if we are going to introduce the mandatory ADR setups. We don't have the relevant skill set available. So these two things were presented before the Chartered Institute, and then they realized that now if all these things materialize, so we do need to have a forum in Pakistan who can train people, who can give that required skill set, and then they can act as arbitrators, and it will not only provide them with the opportunity to be appointed as an arbitrator, they can get the international appointments as well. So, well, while this whole angle was going on in Pakistan, globally we are witnessing a new era of global legal system. There are a number of jurisdictions where adjudicating the court of law is considered to be the last resort. You have to have those mandatory forms of ADR before knocking at the judiciary. So we still have to develop those mechanisms. And to be honest, at that time, the discussion of modernizing the Pakistani laws, especially with regard to the ADR, and the modernization of the procedures, especially the civil procedure, that everything was under discussion. And I personally used to think probably this is going to take centuries for us to modernize our laws, but yet now I see in less than 2 years, we have got ADR acts enacted in KPK, in Punjab, in Federation. Probably we are going to to see the same ADR Act like enacting in the Sindh Assembly probably soon. And with the amendments to the CPC, we are moving towards the provisions of these new ADR facilities. Like most of these acts, the ADR acts, they now require to have a certain form of mandatory ADR at a certain stage of proceedings. And probably if these things are going to be implemented in its true spirit, probably we don't have those arbitrators and skilled people available who can handle all this. Being part of the legal fraternity, I do understand we do have certain observations, reservations with regard to these amendments and ADR acts. We sometimes our legal fraternity, they consider it as a threat, but being a lawyer, I don't see it as a threat. I think it's a wonderful opportunity. I will not only be working as a counsel, presenting before various courts of law, I do have now an opportunity to act as an arbitrator. I think it's kind of a satya you have been given the same role of dispute resolution among people. I can do that. Plus, it will also provide me an opportunity once I am trained in my local jurisdiction. It will pave the path for me to get the international appointments. To be honest, besides this domestic arbitration, Pakistan is very famous in losing international arbitrations. We do hear every now and then. We being the law students, we do follow these investment arbitration decisions, which are being name it starting from liquidate to the rental powers. Nowadays, the broadsheet ones. The only problem we are facing is the lack of expertise, the lack of skill set, nothing else. And we don't have those people available within our jurisdiction who can actually go and present us before these arbitration tribunals. Like a couple of weeks ago, I just saw the news in probably Dawn News with the caption that despite high number of lost arbitration, Pakistan has not been able to develop the pool of expertise who can actually go and present us. So this international regime and as well as the domestic arbitration, I think it's a wonderful time where we have to upgrade ourselves as lawyers, and we have to be part of this change, and we have to embrace and facilitate our motherland with regard to providing this with regard to providing the expeditious justice to the people of Pakistan. And to my fellow lawyers, I believe this is going to be a wonderful opportunity. We need to pin them down. We need to be prepared and to start getting these trainings, because this training is important in order to procure, in order to become an arbitrator. It's not possible for an ordinary lawyer to adjudicate and start giving decisions without getting the appropriate and enforceable award. And for this, especially at the end note, I would like to offer myself after this seminar. I'll be available for my fellow lawyers of the Karachi Bar Association. Provide any information, whatever you require, I'll be available. And I'm thankful for you to provide me this opportunity to share my insights and thank you.
Thank you so much, Mia Javed sir. I think with this note and with the industry inside and the opportunities that the CIArb platform and including the Pakistan branch is promising and will provide in the coming times ahead, I think at this point I'd like to have a quick review and remarks from our special guest. We have with us the President of Karachi Bar Association, Mr. Adr Findings. We also have with us the Secretary General, Mr. Ahmed Baraij, and we also have someone flying from Islamabad, Mr. Dr. Rahim Aman, who has been very deeply interested in the ADR and the ADR perspective in Pakistan. So I'd want them to give their overview and how they see the branch, the CIArb Pakistan branch, entertaining the fraternity and helping them build the arbitration community at large.
I'm grateful, Mr. Asr Fahid, for review the Chairman Legal Education Committee of the and the coordinator, Mr. Zahir Ahmed. And I'm also grateful to my colleagues in the student, the opportunity, special opportunity given by Karachi Bar Association, Mr. Karachi Board Secretary of the Bar Justice Commission. I'm very grateful. Thank you, arbitration disputes resolved by the Islamic. I feel the resolve the disputes are so come the lot of Jews working in the Karachi and also so the South. It's very clear. Resolve Islam is very clearly say resolve the dispute by the nation. The good start is the first time welcome the all guest speaker and other friends. Thank you for from the Lahore, my friend, and all the other members. I'm very grateful on behalf of the Karachi Bar Association and thanks especially to start meditation and God with you and the new youngs lawyer. Especially see the audience is a very young wife facilitated the dispute resolution and in the future. Thank you.
Thank you so much, Mr. Zahi Qureshi, President, Karachi Bar Association. Please take a round of applause. हमारे यहाँ बड़ी से मौजूद हैं जिनका तारुफ शायद मेरे पास अलग करो कि इसी के साथ में साइन करने में बड़ा साइड में थोड़ी देर बाद आप से एक और जस्टिस कमीशन आपको बहुत प्रयास में हमने यूथ को मोटिवेट करते हुए मुख्तलिफ मेनस्ट्रीम टॉपिक्स की अवेयरनेस के ऊपर काम करते हुए देखा है हमने Dr. Mohammad Rahim Awan Sadan, thank you so much for being with us. Please, sir, over to you.
Bismillahirrahmanirrahim. Alhamdulillah. Honorable President, Karachi Bar Association, Thank you for providing this opportunity to me. I'll try to confine myself and cover in the short time I'm one of the video and one of the initiatives taken by the institution of some future planning. No doubt the ADR is one of the mechanisms as moved by a reference to the science. There are no questions of how plan which is valid for the remediation. Surah, दो भाइयों में चुनाव होते there's a perception, the wrong perception about the ADR that it is very likely to affect, perhaps it is very likely to affect and the lawyers won't be able to earn from this profession. If years ago we have said this, that would be right, but at the moment there are a lot of new avenues for the lawyers where if they focus on the ADR and the other, they can earn the name and the fame and also the livelihood, and it would affect their profession. As the commercial arbitration is one of the areas where if the young lawyer focus and the senior lawyers guide them, that is the area where it can earn the international fame and international name. And in the entire life, if you earn from this standard practice, the traditional practice, you won't be able to equate the whatever you will earn from the international commercial arbitration. Same the investment treaty arbitration and the mediation, corporate social responsibility, a lot of areas which you need to know. Why there is no after the human resources after the 22A or the standard practice of the succession. So no doubt that is an area where our lawyers are focusing. But why not? Why the international commercial or treaty or investment arbitration are limited to some specific chambers? Why the corporate social responsibility and the corporate law, corporate governance? Our young lawyers are not thought of that. If they focus on that, definitely with the energy, if they have the knowledge and the level of the education they want, they can do wonders in the legal field. So this, I would say, instead of getting offended from the ADR, I would suggest it is now right time to promote the ADR and find new training opportunities. Secondly, the Law and Justice Commission of Pakistan is working on the establishment of regional commercial arbitration. So that is the area I think we successfully established that in the region. That will open new doors to our lawyers for the arbitration, regional dispute of commercial nature, and this kind of thing. Also, we are working on the model establishment of model mediation systems. And we are working on the training of the lawyers. Yesterday, I was speaking to Zainbai that we have designed 8 ADR programs in the next 4 months, which we are going to conduct in the city. All of them are 2 for the lawyer, 2 for the tax officer, the tax lawyer can join. 4 sessions will be in Karachi. So that will provide you opportunity to learn about the how to use ADR techniques in the tax matters and other matters. You would surprised to know Turkey used to have 36 million cases pendency. If I'm not wrong, more than 36 million, I guess 60 million. And they adopted the ADR tactics. And there is one and now there is 0 pendency. And none of them is done by the courts. Those are done by the lawyers. They train the lawyers for the mediation. Whatever we file to them, the government pay the mediator for that purpose. And for the first hearing, the case is referred to a lawyer who is being trained mediator, and dispute is with them. They conduct the consultation sessions, and in the case they amicably, successfully resolve the dispute. They get financial benefit out of that as well. So now there are billions of the labor cases on the being resolved through this technique. And lawyers are doing much where they never thought before, but by the easy way. एक तो मेरी ये सबमिशन होगी कि हम उस तरफ जाएं कि आपको मीडिएटर ट्रेन करके कि किस आपको रेफर हो, आप उसको मीडिएट करें और आपको स्टेट भी पे करें उसका, और आपको इंटरनेशनल एप्लीकेशन करें वो भी आपको पे करें. तो बड़ी सक्सेसफुल स्टोरी है करनी. और जैसे मैंने किया कि we are going to arrange this kind of training programs. तो दूसरा मैंने ये वैसे काफी सजेशन की है today. I would again recommend right. We got some funding for the innovation in legal education. So why not design some legal education program and share with the Law and Justice Commission for the approval of funding? Inshallah, we'll do our best. और दूसरा सब है I recently visited the city board to stay and inside the I brought Honorable Chief Justice here and during that the bar was outside the sitting place to me and over. So unfortunately the Law and Justice Commission का भी problem है उसे क्या है कि हम direct funding बात करेंगे लेकिन हम through session facilities create करते हैं. तो मैंने अभी session के हिसाब से मीटिंग में कहा है कि आप अपनी सिटी कोड में जो है शेल्टर स्कीम का साफ पानी टॉयलेट फिल्म स्कीम में डालकर भेजिए अपार्ट बेस करेंगे उसे डिटेल तो बेनिफिट होगा सब पर. Thank you very much.
Thank you, Dr. I think that was very helpful, and I think with this team, I think our program and our motto is more than this, that the fraternity itself needs
the support of this chapter in order to provide assistance and the speedy remedy for to assist the judicial system simultaneously. Now, with this, we like to have our last speaker, who is the General Secretary of Karachi Bar, for his quick views, Mr. Adr Findings, on how he sees CIArb's Pakistan chapter in Pakistan.
Bismillahirrahmanirrahim. I am thankful to my brother that he has considered our work and he has given opportunity to our members to have this seminar, and they must learn something and they must get some idea about this arbitration. I personally think that the arbitration is one of the best idea, and out of 100 I think we can remove or resolve, either you can say 90% issues through arbitration. Well, generally when we are sitting in the bar, we have seen that number of the time people they come, and on daily basis I think we deal with around 4 to 5 minimum issues, and out of 4 to 5 I think in a month we hardly get 1 or 2 issues that where we are unable to resolve or arbitrate. We do the mediations and we get succeeded. Now, in international level, when we talk about the arbitration, definitely there is a standard, and the people who are interested, like our young lawyers, they must need to observe the course also. They must need to learn the procedure of recording the evidence also, and they have to be fair, and their character should be such a fair that when they apply for any arbitration, then throughout their career there should not be any stigma over their career, because their position would be just like a judge, and they are just think their opinion would be valuable to everybody. And at the end, I would request to the Honorable Chief Justice of Pakistan that to make some arbitration course, or just like this institute, you adopt such kind of institutes and you give opportunity to them, and for the purpose of some, you can say for examples and for some other reasons, you can refer the matters, and thereafter you can get some idea that whether this function or this idea is working or more. So thereafter you can have some good things. So I personally appreciate, and I think this can work if we give them opportunity. So I'm grateful to my friends all who come here, who give our members opportunity. Thank you so much. Good luck for that.
Thank you, Mr. Right. I think with this we will quite wrap up, and we'll take a few key findings from the event of today. That with the official launch of CIArb in Pakistan, I think the bar and the Netherlands bar have welcomed it with a huge applause. And accordingly, our aim is to conduct more trainings, more seminars, on the sole basis that CIArb is trying to provide a platform for training and also be an active provider of dispute appointment services. So, in order to sum up, I think I'd like to especially thank all the speakers, including namely Mr. Tom, Mr. Nasser, Mr. Raj, and members of the bar. And hopefully, we will be in a position to conduct more seminars at other district bars and other regional bars in order to promote the world of CIArb. And just to just to take a quick I'd also like to add one more thing to this, that not only lawyers, but CIArb has a platform that starts from students as young lawyers until the chartered level of arbitrators. So we have a variety of things that we will foster, and we look forward to working again with the bar in order to promote the aim of CIArb in Pakistan. And in the end, I once again like to thank our esteemed special guests for their input, and Karachi Bar Association for providing us a platform to conduct this virtual hybrid event. And hopefully, we look forward to many more in the coming times. Thank you so much.
I'm a